in all likelihood, that state is going to flip. And then you have the opportunity to run into court and delay and run out the clock and do whatever you can to make sure that stack of segregated ballots that are valid, that everybody agrees you have a right to vote, don't get counted. That's what happened in 2000 in Florida. That's how George W. Bush got to be president.
Welcome to Law and Chaos. The independent state legislature theory is back bigly. If Republicans can't win this election with their wildly gerrymandered electoral college map, they will just steal it and claim that the Constitution gave them the right. Also, Elon Musk is breaking everything again. We got a lot to cover, so let's get after it. Hey guys, I'm BlueSky. With me as always is Andrew Torres. Andrew, how are you?
I'm good, Liz. How are you doing?
I mean, we're 1 week out from the election. I think we're all living on...
suspended question for now. Let's everyone check back in sometime after November 5th. Fair enough.
Yeah, I think we're all just living on Pepto-Bismol and gummies at this point. But okay, today we will talk a lot about election-related litigation because that's all that we're thinking about. Before that, though, let's discuss Elon Musk, who is, of course, making himself an election issue.
Yeah, I think I read yesterday that Elon Musk's America PAC has spent $133 million to prop up Republican candidates, mostly Trump. And, when their guy does it, that is just patriotism. When, Mark Zuckerberg spends money on voting infrastructure, that is, of course, election interference, meaning that everything must be canceled. Anyway, leaving that aside.
Use the word Soros for Musk there.
Ooh, okay. But that's aside from the hundreds of millions of dollars, at minimum, in free advertising and other in-kind contributions that Musk has clearly given the Trump campaign on Twitter X, right? Through personally boosting vicious lies about immigrants. Like, I never sign into Twitter, and I get 5 notices a day from, Jack Posobiec and whatever. Like, it's gross.
Yeah. The PAC put out, speaking of gross, a particularly vile ad called Kamala is the C word this weekend because their Hitler rally at Madison Square Gardens wasn't vulgar enough. Although, look, the Supreme Court used a case from an anti-Hillary group called Citizens United, Not Timid. Get it? Get the acronym. That was their vehicle to break campaign finance law. So I suppose I should not be all that surprised at the gutter coarseness of the Republican political dialogue.
Yeah, and while we're speaking of the world's whiniest billionaire, we do have a post up on the website from you and I on Elon Musk getting sued by the owners of the Blade Runner 2049 IP for copyright violations at a Tesla shindig 2 weeks ago that was apparently a disaster in its own right.
I mean, look, we could do a whole master's thesis on the meta commentary of Musk using his stupid AI to steal human-generated art from a movie that is about the dangers of mixing up humans and machines. Like, my guy, have you ever seen any of the Blade Runner movies? Because they're not an advertisement for Neuralink.
Excellent point.
Sorry. But okay, let's talk Musk and elections for a second, because Philadelphia District Attorney Larry Krasner just filed a civil action against Musk and his America PAC for violating the state's ban on private lotteries. And look, you guys remember we talked about this last week and got a fair amount of pushback because we said we did not think that it violated federal election law for Musk to give away money to registered voters who signed his stupid petition. Like, the petition is functionally a data gathering exercise where registered voters from swing states who pledge to support the Constitution, especially freedom of speech and the right to bear arms, well, they'll get $47 each or $100 in Pennsylvania, more if they refer their friends and family. Musk does not appear to be making the $47 payments yet, aside from a few checks that were hand-delivered so he could tweet out the recipients on social media. But in addition to the $47, he's giving away $1 million to one lucky signer per day through the election.
Yeah, and we flagged and specifically reserved judgment on the gambling law question, right? Because like most states, Pennsylvania has a state lottery, and the state can outsource that lottery function to private companies, and they all do. But private companies can't just set up their own lotteries, right? Like having the monopoly is kind of the point. So in Pennsylvania, it is both a crime and a civil nuisance to run a private lottery. And this is being brought as a civil case by the district attorney. So the complaint alleges America PAC and Musk are lulling Philadelphia citizens and others in the Commonwealth and other swing states in the upcoming election to give up their personal identifying information and make a political pledge in exchange for the chance to win $1 million. That is a lottery.
Yeah, I should note that I fired up the Wayback Machine, but was not able to retrieve any prior versions of this petition. As currently constituted on the website, it says, quote, each day, one petition signer from either Pennsylvania, Georgia, Nevada, Arizona, Michigan, Wisconsin, or North Carolina will earn $1 million. I'm not sure about the definition of earn there. Like, is that a performance bonus or something? Note that they do not say that said recipient will be randomly selected, although the complaint itself does, and it has quotation marks around it. So perhaps Musk himself said it in one of his public appearances announcing this prize. Also, as the DA's complaint points out, 3 of the 8 recipients so far were in the audience at the rally where the check was awarded, which makes it seem like it's maybe not so random an award, considering, right, if they're saying there's 1 million signatories and wow, person just so happens to be in the room right now, come on up, right? That's pretty much not random. Also, the fine print on this document says, quote, payments of $600 or more will require the referrer to provide a signed IRS W-9 so an IRS 1099 can be issued. And I'm sure that America PAC is going to argue that this isn't a lottery. It's more like the signers are, subcontractors, or they're getting a referral fee and they get a 1099 for it. I don't know. Gambling winnings, I think, are Form W-2G. So, I see what they're trying to do here and insulate themselves from accusations that they're running an illegal lottery. But I don't think it's going to work because, how can putting your name on a list make you a subcontractor or even a referrer? My man, that's barely even a fig leaf.
Yeah, and D.A. Krasner really had this covered. I was impressed with the way that he framed the argument in the alternative in the complaint, right? So I think the 2 counts really are disjunctive. So the DA is essentially arguing that either Musk is running an illegal lottery, which of course is what he's doing, right?
Yeah.
But that would require it to be random. Or Musk isn't running an illegal lottery, at which point he's violating the state's consumer protection laws because Musk doesn't actually intend to give all of the people who provide their information to him a fair shot at the money. And he still wants the information equally from all of them and, all of their friends. So here's how the complaint puts it. To be clear, it would be no defense for America PAC and Musk to argue that it was not engaging in a lottery if their scheme actually did not involve a chance or random selection of winners. In that event, A, they would be admitting to acting deceptively and in violation of the Commonwealth's consumer protection law, and B, they would still be in violation of the Commonwealth's prohibition against the operation of unlawful lotteries.
Womp womp. The DA is asking for injunctive relief to make Musk knock it off with these $1 million prizes, and the case was just filed this morning as we're writing this, so obviously we'll keep you posted. There's been no ruling yet. I would say that Musk may believe he's totally above the law and be perfectly content to disregard a court order. I doubt the treasurer of his PAC feels that way, though. So there may be competing incentives here. We will see.
I think that's an excellent point. And before we leave Elon Musk, I want to follow up on a story we've covered pretty extensively a little over a week ago in a piece that you titled Elon Musk and America's Worst Judge, Tag Team Match versus Reality. We wrote about Twitter's garbage lawsuit against Media Matters for America, alleging that the nonprofit defamed him by truthfully reporting that Nazi content was being served alongside ads on X Twitter. Musk, of course, filed that complaint in the Northern District of Texas, Fort Worth Division, so that he could draw Reed O'Connor. We have talked about Judge O'Connor at considerable length. You can read all about that in our piece, lawncastpod.com. But as part of that garbage lawsuit, Twitter also served a bunch of plainly illegal discovery requests on Media Matters, seeking the names of confidential donors because something George Soros. To go back at that. Yeah. And look, That's ridiculous. But what Judge O'Connor did was lied about Media Matters' conduct in the case. And he claimed that they'd waived all complaints in perpetuity throughout the universe. And it was truly staggering behavior, even from Judge Reed O'Connor.
Yeah, that was a really good post. You're the one who wrote that post. That was a very good post.
Oh, thank you. And anyway, Media Matters' appeal went to the Fifth Circuit, and anytime anything goes to the Fifth Circuit, you and I hold our collective breaths because that court is also crazy. But apparently not quite crazy enough, because last Friday, the Fifth Circuit reversed. It carefully ignored the waiver issue that Judge O'Connor lied about. Like it didn't want to call him out for having mischaracterized the record. But instead, what the Fifth Circuit said was, okay, look, whatever happened, and we're making no judgments here, these discovery requests are not relevant under Federal Rule 26. And so, no, Media Matters does not have to answer them. And, pointedly, the Fifth Circuit did not say, it's kind of weird for us as an appellate court to be doing the job of a trial court and ruling on the relevancy of discovery requests, which it is. But hey, win's a win, and I'll take it.
Yes. And finally, relatedly, Twitter has now changed its terms of service to require that all lawsuits against it now must be filed in the Northern District of Texas. Wow, I wonder why it's mysterious, huh? All right, guys.
Sure.
Seriously, I'm not trying to be a bully, but get off Twitter. You do not need to be on Twitter. Just say goodbye. Everybody will be better off. Okay, but do not say goodbye to us, although we are taking a brief ad break, unless you are a subscriber at patreon.com/lawandchaospod or at lawandchaospod.com, or in which case, nope, not for you, baby.
Before we get back to the main show, we want to thank our subscribers, our supporters over on Substack and on Patreon.
On Substack, thank you to Holly Christensen, Jason Michelle, Jonathan McFarlane, and Thomas. And on Patreon, thank you to Christopher McLaughlin, Markin0024, Mark Garazio, Becky Houghton, Canadian in London, Melissa, and Alan Brent.
And thank you on Patreon to DJ Head, Matthew Aarons, Randall Childs, Eric Lucas. I have an odd number of testicles, and the number you're thinking is wrong.
Wow, okay.
I'm thinking 5. So, Mark E. Krause, Kevin Golden, Steve Seal, and Michael Wedding. Thank you all so much for supporting us. We could not do this show without your support, so we appreciate it more than you could possibly imagine.
Thank you, guys. Okay. Let's talk about Republican election lawyers, because these assholes are wilding out lately. We talked last week about the 3 election litigation buckets, the crazy, the chaos, and the point shavers. Go back and listen to that one if you haven't. I'm really proud of the show. But let's focus for a minute on the return of the independent state legislature theory, since that looks like it's going to be a big theme in the GOP lawsuits this cycle.
Yeah. So, like we said in episode 77, the independent state legislature theory has its modern roots in the Supreme Court's per curiam opinion in 2000 in Bush versus Gore. Here's the relevant language, and you can see why the nuts have seized on this. The individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the Electoral College. This is the source for the statement, in a prior case, that the state legislature's power to select the manner for appointing electors is plenary. Right? That means absolute. It may, if it so chooses, select the electors itself, which was indeed the manner used by state legislatures in several states for many years after the framing of our Constitution. History has now favored the voter. When the state legislature vests the right to vote for a president in its people, the right to vote as the legislature has prescribed is fundamental, and one source of this fundamental nature lies in the equal weight accorded each vote and the equal dignity owed to each voter. Okay, that's good. But then the state, of course, after granting the franchise in the special context of Article 2, that is for president, can take back the power to appoint electors. Now, you see why that throws up a lot of red flags. Right. The Supreme Court in 2000 made this statement in a terribly convoluted opinion designed to stop the recounts and ensure that George W. Bush would win the election by not flipping votes in Florida that would have flipped to Al Gore. They basically said that looking at the hanging chads, counting the undervotes to try and figure out voter intent was too subjective. And so the judicially mandated recount ordered by the Supreme Court of Florida had to be halted because it violated the Equal Protection Clause of the 14th Amendment. But that language in the opinion about the legislature having plenary authority under the Constitution's Elections Clause and the ability to take back the franchise from the voters has been interpreted by the wingnuts as meaning that nobody, not judges, not secretaries of state, not ballot initiatives, not state constitutions, not governors, nobody but those state legislatures gets to make election rules. And that's crazy. And in a 6-3 decision, and I will tell you, Liz and I had an argument off the air about whether Moore versus Harper was 6-3, as she correctly thought.
It was a little bit both. We were a little bit both, right? Because it's Thomas and Alito.
But more technically, you were correct, yeah.
All right.
Anyway, our Supreme Court's right wing is messed up. Anyway, Moore v. Harper involved the rest of the Supreme Court pushing back on that in a very limited way, right? And so that case said the Elections Clause does not insulate state legislatures from the ordinary exercise of judicial review. So that means state courts can review election laws, and presumably there's some role for federal courts to review election laws. But we don't know. We don't have any ruling from the Supreme Court about secretaries of states. We don't know if the Supreme Court is going to go nuts and claim that, say, anti-gerrymandering ballot initiatives violate the Elections Clause, or secretaries of state ordering election officials to keep counting contested ballots do so. And it's bad.
Yeah. And I just want to kind of highlight how this independent state legislature theory has become deeply ingrained in GOP thinking. Like, here's Trump explaining to Joe Rogan why the election was illegitimate 4 years ago.
That election was so crooked. It was the most crooked election.
Okay, but give me some examples of how.
Well, let's start on the top and the easy ones.
Okay.
They were supposed to get legislative approval to do the things they did, and they didn't get it. In many cases, they didn't get it.
What things?
Anything.
Legislative approval
like for extensions of the voting, for voting earlier, for this,
right.
For all different things. By law, they had to get legislative approvals. You don't have to go any further than that. If you take a look at Wisconsin, they virtually admitted that the election was rigged, robbed, and stolen. They wouldn't give access in certain areas to the ballots because the ballots weren't signed. They weren't originals. We could go into this stuff. We could go into the ballots, or we could go into the overall. I'll give you another one.
Are you going to present this ever?
Okay, so that's obviously word diarrhea, and I am quite sure that Donald Trump has no idea what the independent state legislature theory is, and probably neither does Joe Rogan. But what Trump is saying there is that the votes in 2020 were illegitimate because officials made it easier to access the ballot during COVID, and that violated the electors clause because the legislature didn't sign off on those changes. That is 100% the independent state legislature theory, and it's frankly contrary to the Moore v. Harper holding, since most of those changes were greenlighted by courts. And look, since then, in 2022, we passed the Electoral Count Reform Act, which one of the clauses of it says once the legislature has kind of set out how they're going to conduct the election, it can't seize back the electors, after the state has already voted. Once they've set the election in motion, they don't get to seize the means of productivity, as it were. But okay, Trump doesn't give a shit about the details, and neither do his goons, particularly this dipshit named Ivan Reichlin, who calls himself Trump's Secretary of Retribution. You may remember him from 2020, since he was the creator of the so-called Pence card theory. That is, he popularized the plan to have Pence reject the real electors and substitute the fake ones.
Yeah, this guy is deep in the grift, and I regret a little bit giving him oxygen here. He's big pals with Mike Flynn. He shows up at these mega conferences, and this cycle, he's pushing the independent state legislature theory hard. His particular view is that in swing states where legislatures are dominated by Republicans and there is a Republican governor, they should just award all the votes to Trump on November 5th.
Have you thought of, and why aren't you calling on the state legislatures in the entire country to just go ahead and convene on November 5th to allocate their own state's electors? At a minimum in North Carolina, New Hampshire, Nebraska, Arizona, Georgia, and Wisconsin, so that those states guarantee that no illegals are voted, no illegal drop boxes, no illegal signature non-verification going on, and it's fully free, fair, transparent, and it can be live streamed on X, Rumble, and C-SPAN for the whole world to see as the world watches that state legislature hold that vote on November 5th to allocate those states' electors, so that Arizona doesn't have to wait 10 to 13 days for the results.
Yeah, I mean, why on earth would you want to wait for the results of an election when you could just steal it?
Yeah, I note that he includes New Hampshire, which no one thinks will go Republican, along with Nebraska, which divides its electoral votes so that Harris will likely earn one vote in Nebraska 1. She's I think like maybe 10 points ahead in the polling there.
Yeah, that's the Omaha congressional district.
Right. But Reichlen is straight up talking about stealing votes that Trump could not possibly win. I mean, I know that's not like the worst problem here, but like, come on, that's not democracy at all. Also, later at that event, Maryland Congressman Andy Harris suggested that the North Carolina legislature should simply cancel the election since lots of Republicans were affected by Hurricane Helene, and the legislature could simply award the state's 16 electoral votes to Trump directly, which got a lot of attention, although the recording is a little garbled. We're not going to play that one for you. But it's just further evidence that the independent state legislature theory has basically rotted the brain of the GOP.
Yeah, and we're going to talk about how that's gotten put into legal practice and other election shenanigans after this brief ad break. And we're back. Okay, in episode 77, we told you about the Republican Party's chaos challenge to mail-in ballots in Pennsylvania. That state has this Byzantine system put into place by Republicans as a deliberate trap for the unwary and an excuse to not count legitimate votes. So if you vote by mail, you fill out your ballot. Then there's an outer envelope. Then there's an inner security envelope, and you have to date and sign that inner envelope. And if you screw any one of these things up, the ballot doesn't count. So back in 2002, a Republican Congress and a Republican president signed a bipartisan bill called the Help America Vote Act, or HAVA. That created the system of provisional ballots that we still have today. That was a direct response to the 2000 election, where people were turned away from the polls and not allowed to vote at all in an election that, mathematically at least, turned on a 537 vote margin in Florida. And so people who were excluded and not allowed to vote were pretty mad and demanded that George W. Bush do something about that. And so what Congress did was get together and say, okay, look, if an election official raises a question about whether you're entitled to vote on election day, we're not going to let that person just unilaterally make you go home and disenfranchise you. Instead, you can cast a provisional ballot. And that ballot will be kept separate, it'll be segregated, and election officials can look at it after the fact. And if it turns out that you were, in fact, legally entitled to vote, it gets counted. And if you did something, if you already voted, if you weren't legally entitled to vote, then you throw that out, right? Because obviously you don't get 2 votes for the price of 1 by voting provisionally. Republicans then tried to use that language promulgated pursuant to the Help America Vote Act to try and say in Pennsylvania that if you cast a vote by mail and the system rejects it because that security envelope got screwed up, too bad. You've, in their view, already voted, so then your provisional ballot should be thrown out, even though that mail-in vote won't count because of the envelope thing. So not stopping double vote, like you get 0 votes for the price of 1 under that view. And the Pennsylvania Supreme Court, in a terrifyingly close 4-3 decision, rejected the voter suppression interpretation in favor of, what the law obviously means.
Right, and then by the way, the Pennsylvania Supreme Court flipped last year. This could easily have gone the other direction.
Yeah, that's right. And now the Republican National Committee, represented by super firm Jones Day, right? I mean, they are the coat factoryest of coat factory firms. Right? They are the ones that were bullied into refusing to represent Trump in election denialist lawsuits in December of 2020.
Wait, whoa. We didn't bully them. We shamed them. And we absolutely should have shamed them. They were ashamed to associate with Trump, particularly after January 6th. But no, you should be ashamed. You should be bloody ashamed.
I agree. I meant that sarcastically because that shame has evaporated. They now represent the Republican National Committee, and they have petitioned the Supreme Court for a stay of the Pennsylvania Supreme Court's order and certiorari to reverse that decision. And I really want to highlight three things from this petition because they're all terrifying. So first, and I think most critical in terms of what this will actually do, is the request for relief that they've made in the alternative, right? Like, obviously, the RNC wants a ruling that enjoins the Pennsylvania Supreme Court's rules and reverses it and says, but if Chief Justice Roberts and the Howler Monkey Wing isn't game for that level of election interference, here's what they've offered them instead. They say, in the alternative, if this court determines that a full stay is not warranted, applicants respectfully request that this court order that provisional ballots cast by individuals whose mail ballots were timely received but invalid, i.e. with the envelope problem, 1, be segregated from all other ballots, and 2, if counted, be tallied separately and not included in the official vote tally, right? And it's not hard to see what they're trying to do there.
Yeah, I would 100% agree. Like we said on the last show, we think that the provisional ballots is where they're trying to, kind of replicate Bush v. Gore, that they want to have a pool of votes which can be knocked out if they represent the, Harris margin of victory. And that's what they're doing. So in previous elections, when they've tried to segregate a pile of votes, the courts have not let them do it. Because if you think about it, like once the votes go in the regular pile, it's not like you can pull them back out and, determine the voter's inclination, right? You can't give Harris a haircut, if they later rule that provisional ballots shouldn't have been accepted. Although you can, spend the next 20 years lying that provisional ballots that shouldn't have been counted or whatever. That can be the next big lie. But you can see them, this is their plan across the country. That's why they're mounting all of these voter challenges in places like Georgia. They're going to have all of these poll watchers descend on polling stations and challenge a bunch of voters in the hopes of forcing them to vote provisionally and then, keeping a store, having a pile like a poker chips where you could take some of them off the table and win, even if that's not the expressed wish of the voters.
Yeah, let's hang some numbers on that, right? Like if your poll watchers challenge 1,000 voters on election day and those get converted into provisional ballots, let's assume Trump is provisionally ahead in Pennsylvania by, 537 votes after election day, right? And then you have a pool of 10,000 provisional ballots. Well, you're pretty clear that Harris is going to pick up 537 votes out of that margin, right? So in all likelihood, that state is going to flip. And then you have the opportunity to run into court and delay and run out the clock and do whatever you can to make sure that stack of segregated ballots that are valid, that everybody agrees you have a right to vote, don't get counted. That's what happened in 2000 in Florida. That's how George W. Bush got to be president. So that's a thing that you and I are really, really afraid of. And it's just why I wanted to draw that out explicitly for what the replicate Bush v. Gore scenario means. It means stealing the election. Okay. So that's bad. There's a second thing, and this dovetails with the earlier segment, because you might be thinking, how exactly does the U.S. Supreme Court have an interest in how Pennsylvania courts interpret Pennsylvania law? And the answer is a weird aspect of the independent state legislature doctrine, right? Like, so the RNC's brief argues that the majority's ruling is so unreasonable that it violates the elections and electors clauses of the U.S. Constitution, and put a pin in those two clauses. Because, Liz, you saw this one coming.
Well, I think a lot of people saw this coming. But yes, one of the dissents in the Pennsylvania Supreme Court opinion really begged the RNC to tee up this independent state legislature issue for the Supreme Court. So that was written by a justice named Mundy, who claimed that, quote, the majority's analysis is too far divorced from the legislature's clear directives regarding mail-in voting to withstand any scrutiny. Its holding usurps the legislature's unmistakable directives and supplants them with a new procedure for counting provisional ballots after a canvass has determined that the elector's mail-in ballot is disqualified, which is so anti-democratic. And also, as I recollect, in the last cycle, there was a similar dispute. And I believe this is the lawsuit that Rudy Giuliani actually entered his appearance on. It was not the argument that he put forward in court. That was just pure gobbledygook. But the actual lawsuit in which he entered his appearance was about curing ballots. So if voters in County A were allowed by the state election official to cure defective ballots if they didn't date it or sign it or whatever, and then that I think what was happening is in County A, election officials were contacting said voter and allowing them to come in and fix their defective vote. And then in County B, that wasn't happening. And so the lawsuit alleged that voters from County B had the right to, I don't know, overturn the election because they hadn't gotten the same. The case got tossed. It was a really ridiculous lawsuit. But the point is that in some sense, the RNC has run this argument before, and they also lost that time, right? That they've said, you shouldn't be allowed to correct your ballot if you screw it up. And a state court decision which held, and I'm quite sure that they took this all the way up as far as they could, said the fact that, you could fix your defective ballot didn't, violate the legislative intent or something. I mean, I'm sure that they're going to say that also was wrongly decided and invite the Supreme Court to step in. And believe me, if it represents like whether Trump gets to be in the White House, I'm quite sure that they will. But Pennsylvania has a history of allowing at least some voters to cure their ballot. So this idea that the ballot is cast irrevocably in the moment that it arrives at the registrar's office or, in the mailbox or whatever it is, that's clearly not been the rule in Pennsylvania.
Yeah. And as long as we're being terrified, the third thing that worries me is that this petition is an invitation for the United States Supreme Court to expand the Purcell Doctrine, which is, as we've discussed, the completely ad hoc principle that prevents, redrawing a congressional district that is racially gerrymandered to hell and back 18 months before an election because, that's just not enough time for the voters to understand and react to the changes. But somehow means that the court should potentially disenfranchise tens of thousands of Pennsylvania voters, 10 days before the election if those ballots would probably lean Democratic. So here's the RNC's ask. They say, although this court has not yet had occasion to apply Purcell in the context of reviewing last-minute changes to federal electoral rules imposed by state courts, the rationales behind Purcell apply equally with full force here.
Right. So just to spell that out really clearly, if the Purcell Doctrine says you can't change the district lines too close to an election because it will cause voter confusion. The Purcell Doctrine, and I've seen this applied, I believe that Judge McBurney in Georgia, when the Georgia State Election Board tried to impose hand counts, he said, no, look, see Purcell, you can't make changes on the eve of an election. So the Supreme Court hasn't applied it to rule changes. I think it's, I think that's a sort of a disingenuous thing. It's not like anybody's confused about the rules and won't be able to cast their ballots. But look,
it's entirely, not to interrupt, it is entirely disingenuous in two ways, right? So first, as a principle, if you were going to apply it to rules, you would want to err on the side of permitting voting rather than prohibiting voting.
Yes.
That's not only consistent with the Constitution, it's consistent with every piece of legislation passed by Congress, even if you think, there's massive voter fraud or whatever, disenfranchising voters is a fundamental evil. Okay. And number two, we're not talking about changing the rules. We're talking about implementing a procedure that complies with what the state system spits out, right? So when your ballot gets rejected in Pennsylvania because it's mailed in and it doesn't have that inner security ballot, you get an email generated by that computer system. It's called SURE, S-U-R-E. And that says, hey, your mail-in ballot has been rejected. Go vote provisionally on election day. That's not a change to the system. That's what it currently says. And what the RNC is saying is, well, yeah, but it doesn't say it's going to count. And, if that's not a reason not to vote Republican and not to tell your family and friends who were thinking of voting Republican not to vote Republican, I don't know that I got a better one for you.
I mean, there was that whole Nazi rally thing, but yes. Okay.
Oh, yeah, okay. Fair point.
Fair enough. All right. So that case, the Pennsylvania case, is being brought by Jones Day. And as we said, those are very good lawyers, right? They can mount a credible case at the Supreme Court. But as you will recollect from 2020. That's not always the case with MAGA lawyers. So let's go back to the other guys for a second, because here's a clip of our old pal Cleta Mitchell from a story this morning in the New York Times about election deniers this cycle.
I've been involved in election integrity, election law for a long time. But it was only really earlier this year, in January of this year, that I began to really think about, I think God put this on my heart, that I really needed to pay attention to this situation and to learn as much as I could about what actually is happening with regard to citizen and non-citizens getting on the voter rolls and voting.
Old Cleta's on a mission from God to find the election fraud. She knows it's there. She has faith.
It's 106 miles to Chicago. Oh, Grandma, like, let's just get you back to your room. And,
yeah, I mean, Cleta's not like...
the election fraud will go away.
Yeah, right. She's not Ivan Reichlin. She's, Ivan Reichlin is pretty much just a MAGA grifter, whatever. I mean, he actually is a lawyer. I think he's a lawyer, whatever. But Cleta Mitchell is not Ivan Reichlin. She runs this outfit called the Election Integrity Network that's heavily funded by billionaires who would like to keep their tax breaks and never, contribute to the common weal. So the EIN trains thousands of busybodies to go observe the polls.
I think you're being overly kind here to ex-Foley and Lardner partner Cleta Mitchell, right? Who damn well knows better here, right? And look, calling them...
Counterpoint, she knows because God told her she's on the right path.
But like claiming that these are observers, that sounds like it's Gladys Kravitz from Bewitched, peeking through the blinds to discover the magic, right? Like, and there were 3 ballot drop boxes set on fire this weekend. Yeah. We have seen these people try to mount an actual coup over imaginary fraud claims, right? You have thousands of people or more who are going to converge on election sites on Tuesday, November 5th, with lists of voters in hand to challenge every swing state precinct with the aim of forcing as many people as possible to cast provisional ballots that will be counted last and which Republicans have already tried to block and will continue to do so. Like, they're not busybodies, right? That they are an active threat to democracy as we know it.
Okay, well, that is extremely fair criticism, sir. I guess I would just say that Cleta occupies a sort of middle position, right? She's convinced that the election was stolen last time, that there are millions of illegal voters, and she buys the idiotic independent state legislature argument that legislatures make election law, and thus it invalidates the result of the election if courts or state officials interpret the laws. Basically, the New York Times article is about this plan, though, to force thousands of voters, as you said, to cast provisional ballots, increasing the pool of votes they can potentially knock out if the election is really close in any state. This is their plan. They're clearly teeing up another Bush v. Gore in hopes that the Supreme Court will wait until Trump is ahead and then once again yell, "Stop the count."
Yeah. And speaking of how ad hoc and pretextual the independent state legislature theory argument is, America's least favorite court, the Fifth Circuit Court of Appeals, just sided with the RNC and the Libertarian Party of Mississippi in a lawsuit against various Mississippi state election officials. So, this is Republican on Republican violence, right?
Uh-huh.
What the Fifth Circuit did was struck down a Mississippi state law allowing mail-in ballots that are postmarked by Election Day to be counted for up to 5 days afterwards. And notice, I said Mississippi state law. So passed by an independent state legislature, right? But the Fifth Circuit in this case reasoned that when the Mississippi state legislature did so, exercising that kind of discretion violates the Electors and Elections clauses of the Constitution. And pull that pin from our last segment, right? The Elections Clause is Article 1, Section 4, Clause 1, and it says, "The times, places, and manner of holding the elections for senators and representatives shall be prescribed in each state by the legislature thereof." So this is like one of the major ISL components, right?
Uh-huh.
And that's what the right-wingers cite when they want to toss out democracy. But the Fifth Circuit has now determined that is superseded by the Electors Clause. So that was the Elections Clause, Article 1, Section 4, Clause 1. The Electors Clause says that Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. And so what the Fifth Circuit is saying is that by designating election day, Congress intended to preempt, to fully prevent any state law that would otherwise mean that ballots must both be cast by voters and received by state officials on one day, because otherwise the election day won't be the same throughout the United States. And look, there are lots of problems with this reading, but principally the problem is that this electors clause that the Fifth Circuit came up with as the justification for reading it this way is not in Article 1 of the Constitution. Article 1, if you remember your Schoolhouse Rock, is what governs the powers of Congress. The Electors Clause is in Article 2, which governs the powers of the president. So that particular clause about how Congress shall have election day, which shall be the same throughout the United States, is in between how electors are counted on election day and the clause that says no person shall be president who is not a natural-born citizen of the United States, right? So look, this is not just a placement technicality, right? From our nation's history, from its inception, Article 2 has never been cited, and no lawyer, judge, jurist, theorist ever, left, right, center, crazy, I don't care. If you graduated from a law school, you have never thought that Article 2 is the source of congressional power, because it is not. It is one of the things that is as explicit in our Constitution as anything, right? But now, apparently, there's a reason for a federal court to overturn a state's interpretation of its own election laws.
I'm just going to point out that this opinion was drafted by Judge Andy Oldham and on a panel with Judges Kyle Duncan and James Ho. Like, this is the worst possible panel you could think of. So this is a panel of crazy people. So yes, they're going to do crazy shit.
Yeah, and on the basis of reading that bit from the Constitution's description of the powers of the presidency, that panel, arguably the three worst appellate judges in the country, I'm not sure I would disagree with you on that one, the Fifth Circuit has now held that the Founding Fathers intended that all states must receive all ballots by election day in perpetuity throughout the universe, and that states cannot vary from that scheme, even though, there's that whole explicit the states can choose the time, place, and manner of elections clause that these lunatics love whenever it means that they can throw out Democratic votes.
Yeah, and I looked at that opinion myself today, and I note that they just threw in there, and I think it's probably dicta, but it's dicta they'd like the Supreme Court to pick up that basically says the vote is cast when it arrives, and so if it arrives late, for the purposes of this opinion, they're saying, and if it arrives late, it doesn't count. But also that would kind of impact this provisional ballot issue in Pennsylvania, because if the vote was cast when it arrived, it would mean you had no right to fix it or cast a provisional ballot. Anyway, Congress has explicitly expressed its intent to allow states flexibility in determining how and when to count votes. As we just said, the Help America Vote Act explicitly contemplates that provisional ballots would be segregated and not received to be tallied by state officials until evaluating them after the election day. And that's the same for military and overseas ballots, the UOCAVA ballots we've talked about a bunch here. It is just false that Congress intended for there to be one day after which no votes count. I mean, look, this is an old argument that people made to say that early voting was illegal. I mean, I don't think that they cited this Article 2 clause because that would be batshit. But we have early voting. If the ballot arrives a couple of days late and it's been postmarked, come on. I mean, that said, mail your vote tomorrow. If you're holding on to your absentee ballot, just go take it or put it in a ballot drop box. Don't risk this here. Anyway, the Fifth Circuit's opinion just hand waves away the counterexamples about the, UOCAVA ballots and such. Literally, they say, the fact that Congress authorized a narrow exception for potentially ineligible voters to cast provisional ballots after Election Day does not impliedly repeal all of the other federal laws that impose a singular uniform Election Day for every other voter in America. And no, we just said that. There isn't a single election day anymore. We have 3 weeks of early voting now. We've already had this fight. Simmer down, Andy Oldham.
Except for the exceptions, there's a uniform. I mean, does he not know what the word uniform means? Anyway, I would be remiss if I did not point out the incredibly strange procedural aspect of this opinion, because it explicitly imposes no remedy for its ruling. So I do not know. You want to talk about the Purcell principle? I don't know what this means for Election Day in Mississippi. Here's what the Fifth Circuit ends with. It says, today's decision says nothing about remedies. We decline to grant plaintiffs' initial request for a permanent injunction, which they have not renewed before this court. Instead, we remand to the district court for further proceedings to fashion appropriate relief, given due consideration to the value of preserving the status quo in a voting case on the eve of an election. I mean, I'm sure this is headed to the Supreme Court shadow docket.
Yeah, I think it's going back to the trial court first. I think what's going to happen is that the trial judge, who, by the way, tossed it the first time, that this is reversing the trial court. I'm sure that the trial judge is going to not order the state of Mississippi to reject any mail-in ballots that come in after the election. But who the hell knows? Okay, we will be right back after this brief ad break, and then we will talk about Judge Eileen Cannon and how her arguments may or may not fare well before the 11th Circuit. See you in a second. Okay. In addition to throwing a Nazi rally at Madison Square Garden, I know I've mentioned it about 6 times, but that was really gross. Anyway, Team Trump is also busy trying to do law stuff, although they did actually get a delay, so they're not going to have to file 2 days after the election their next brief in the D.C. election interference case. They got, I think, until the 21st. Whatever, like either he wins and there is no more case, or he loses and the case is going to go forward, and a couple of weeks doesn't make that much difference. But on Friday night, Trump's legal team filed their appellee's brief in the 11th Circuit. That is the government appeal of the stolen documents case, which was dismissed by Judge Eileen Cannon, who is reportedly on Trump's shortlist to be Attorney General. That's what they say. Honestly, I do not think that woman could get confirmed by any Congress.
Oh, you sweet summer child.
No. I mean, and also, like, why would she leave a federal judgeship for a couple of years, like in the D.C. meat grinder, like where she'd have to testify to Congress every month and, Democrats would beat her up and, she's likely to be fired by a tweet if she does something bad. I mean, she's younger than we are. She probably has young kids. I don't think she would want to leave Florida for that shit.
That's a better argument, although, who knows? I mean, Donald Trump may just decide that a sitting judge can also serve as attorney general in his second term.
Right.
Who are we to say otherwise? And, if you challenge that case will get removed to the Southern District of Florida and assigned to Judge Eileen Cannon. So anyway, I'm a bit feeling cynical these days. So on July 15th of this year, Judge Cannon ruled that Special Counsel Jack Smith had not been appointed by law in a meandering 93-page opinion that never really came to a firm landing as to why, right? Like that opinion pontificated about separation of powers principles for 15 pages and embarked on a lengthy frolic and detour about the major questions doctrine and whether Congress provided a clear statement of its intent before saying that, those considerations were interesting but played no role in her decision either. Like, and then there were, I'm not kidding, 20 plus pages about whether Special Counsel Jack Smith should be viewed as a principal officer under the Constitution, right? Like that is someone on a par with the Secretary of State requiring confirmation by the Senate. But before Judge Cannon held, and here I just have to quote directly because nothing but the words of the master will do. The court sees compelling reasons to reach a principal officer designation, but the answer under current Supreme Court precedent is not self-evident, and because this court need not rely on this ground to dispose of the Appointments Clause challenge in the motion, the court elects to leave this matter for future review. I mean, this is just an astonishing opinion. We covered it in detail in episode 47.
Yeah, TLDR, it was very important to Judge Cannon to get rid of this case, but she kind of yada-yada'd over the legal justification for holding that special counsels are unlegal. And okay, I understand why she did that because, let's just point out some inconvenient contrary legal theories. First of all, we have a 150-year history of attorneys general appointing special counsels, and every court which has ever considered whether such appointments are legal has held that, yes, they are. Second, after the grotesque abuse of the process by Ken Starr, who, lest we forget, subpoenaed pictures of President Bill Clinton's penis. Congress and the executive branch both happily let the independent counsel statute lapse in 1999 with the understanding that the independent counsel role would then revert to special counsels appointed by the attorney general in the case of conflicts of interest, right? Like as in a case here where the sitting president and Biden, when he was running for president, like the reason that special counsel Jack Smith was appointed is he was appointed right after Trump, announced that he was running for president. That was to avoid the apparent conflict of interest. And the DOJ has promulgated a regulation to that effect, saying this is what you're supposed to do when you have this conflict of interest. And in the past 25 years, both Republican and Democratic presidents have, in fact, appointed special counsels pursuant to that regulation. It's 28 CFR 600.1. Third, the appointments under this regulation have all been made pursuant to statutes that include 18 U.S.C. 515, which explicitly permits the attorney general to appoint, retain, and direct, quote, any attorney to, quote, conduct any kind of legal proceeding, civil or criminal, which would certainly suggest, along with the fact that we've had all of these special counsels, that special counsels are indeed legal. And fourth, the Supreme Court explicitly concluded that the statutes relied upon here, that's 18 U.S.C. 515 and a bunch of other statutes as well, that those statutes, which were relied upon as authority to appoint Jack Smith, were validly used in 1974 to appoint Watergate Special Prosecutor Leanne Jaworski. And that decision was challenged in U.S. v. Nixon. And, the court said it didn't present separation of powers issues and indeed ruled that Jaworski's subpoena was valid.
Right. But counterpoint, those are four pretty persuasive statements of law and fact. But remember, Judge Eileen Cannon is the judge who essentially invented the doctrine of anomalous jurisdiction to empower her to interfere with an ongoing FBI investigation of Donald Trump in the first place. So, perhaps we shouldn't have been that surprised that she brushed off all of those very powerful arguments when she threw the case out back in July. But because that was a motion to dismiss brought by Donald Trump and no jeopardy had yet attached, right? That means that the government was entitled to appeal that dismissal to the 11th Circuit, right? The government can't appeal an acquittal by a jury, but a legal determination that says you have no authority is the kind of thing that the government can and did appeal to the 11th Circuit. And this is the most important thing to take away from this segment. It's why we're going to end, although in our Patreon bonus, we're going to get into the weeds if you absolutely love the legal minutia, which I know a lot of you do, and I definitely do. But here's what I want you to think about. Look, the 11th Circuit is a very, very conservative court, right? But the review of Judge Cannon's decision is what we call de novo, right? New. That means that neither the 11th Circuit nor the Supreme Court, which is where an appeal will go, owes her opinion any deference, right? They must independently come to the same legal conclusions that Judge Cannon did. And the last time this happened, the 11th Circuit smacked her back to the Stone Age and the Supreme Court said, yeah, go right ahead.
Right. And you're talking about the Supreme Court. Judge Cannon very clearly took her lead on this from a concurrence in the immunity decision by Justice Clarence Thomas. That was an answer to a question nobody asked, right? Nobody was talking about, is the special counsel legal? But Clarence Thomas just went out there and said, I think special counsels aren't legal. And why aren't we arguing about that right now? And Judge Cannon said, cool, I got you. And that was the reasoning that was reproduced in that. But I will say, nobody else signed on to that. Not even Alito, not Gorsuch, not Kavanaugh, none of them. Kavanaugh, by the way, worked for independent counsel Ken Starr. So reversing him. He would never reverse himself. I don't know what I'm thinking about.
Performative contradiction. What's that? Yeah.
Anyway, the point is that I don't think that this opinion by Judge Cannon is going to carry the day. I mean, it may be moot if Trump gets elected because, as he said, he's going to fire Jack Smith 2 minutes later, even though special counsels are supposed to be insulated, but it is what it is.
Yeah, no, and let's be clear, he will have the legal authority to fire Jack Smith, right? Like that's why the independent counsel statute, which was designed to insulate independent counsel from that kind of retaliation, was allowed to expire. We naively thought in 1999 that just the political pressure from obviously appearing to interfere with your own prosecution would be sufficient to shame any president and, was sufficient to shame Richard Nixon, but, Donald Trump is immune. But I can't wait to break down this brief that was just filed by Trump's lawyers, because I think it's really fascinating. I also think there's some efforts to do some real law here. It really, really interesting. And if you want to geek out with us, stick around for the Patreon bonus. And if not, we will see you again on Friday with the next episode of the show. And we'll see you on Thursday with more written content.
All right. Thanks. We'll see you guys. And keep it together, man. I think it's going to be okay, but it's going to be a bumpy ride.
Yep.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Up to Media, LLC, all rights reserved.
I earned my degree online at Arizona State University. I chose to get my degree at ASU because I knew that I'd get a quality education, they were recognized for excellence, and that I would be prepared for the workforce upon graduating. To be associated with ASU, both as a student and alum, it makes me extremely proud, and having experienced the program, I know now that I'm set up for success. Learn more at asuonline.asu.edu.